Royal tension peaked. Harry had explosive fight with Queen's top aide in court over Protection Row. The Duke of Sussex is suing the Home Office because it refused to spend taxpayers' money on his bodyguards after he quit royal life. His lawyers asked Mr. Justice Swift at a hearing in London today to allow full judicial review of the Home Office's decision. They revealed Harry believes the Queen's private secretary, Sir Edward Young, should not have been involved in the February 2020 decision, adding there were significant tensions between the pair. The Executive Committee for the Protection of Royalty and Public Figures, REVEC, of which the Queen's private secretary was involved, ruled Harry would no longer be given the same degree of personal protective security when visiting the UK, despite offering to pay for it himself. The Duke's legal team want to argue the security arrangements set out in a letter from REVEC, and their application when he visited the UK in June 2021, were invalid due to procedural unfairness. Shahid Fatima QC, for the Duke, told the court, he didn't know at that stage that the royal household was involved at all. He was told it was an independent decision. She also said there were significant tensions between Harry and Sir Edward Young, at that time. In written arguments, Ms. Fatima said Harry was not given a clear and full explanation of the composition of REVEC and those involved in its decision-making, for example, that it included the royal household. She also said his understanding was that his points regarding security, which he passed on to the royal household, were being fully and properly communicated to REVEC. Ms. Fatima said he was denied the opportunity to make representations directly to REVEC and was materially prejudiced because, among other things, his offer to pay for security was not conveyed to REVEC before the decision was made. She added, he does not know what else, as communicated by him to the royal household, was not fully/timelessly conveyed to REVEC. He was deprived of the opportunity to comment on the appropriateness of REVEC's process, and the involvement of certain individuals in the REVEC process prior to the decision being made. It is arguable that, if there had been a fair process, REVEC would or could have reached a different decision. The filing also read, Prince Harry's offer to pay for police protection was made at a meeting on the 13th of January 2020 at which members of TRH, the royal household, were present, and is also referred to in an email to Sir Edward Young of the 16th of April 2020. There has been no explanation of why the offer was not conveyed. Harry has now hinted at a second lawsuit, with the court filing adding, Prince Harry has engaged in pre-action correspondence for a proposed second judicial review claim in relation to these matters, and intends to issue that claim shortly. Lawyers for the Home Office say REVEC was entitled to reach the decision it did, which is that the Duke's security arrangements will be considered on a case-by-case basis, and argue that permission for a full judicial review should be refused. Sir James also said there is no basis for the court to conclude that it would be anything other than highly likely that allowing Harry to make representations to REVEC before the decision was made would not have led to that decision being substantially different, or even at all different. Sir James Aide QC, representing the Home Office, said in written arguments that any tensions between Harry and royal household officials are irrelevant to his change in status. He said, in his skeleton, the claimant now refers to objections he might have made to any role being played by officials of the royal household in REVEC's decision-making, apparently because of personal tensions he felt with them. But there is no bias challenge, and any such tensions are irrelevant to the undisputed fact of the claimant's change in status which led to the decision of REVEC. The inability of the claimant even now to explain how a process of representations could or would have assisted is striking.